Well, thanks very much. Great day yesterday and a good day coming today, for sure. I think that the interest in this conference is a true testament to the importance of the topic. I'd like to call out the Civil Justice Aggregate Litigation Data Project that Peter may have talked about. It's described in the program, but this is something, it's an initiative that is happening at NYU, which relates to the topics that we're talking about, and I think very important. So I'm a professor here at NYU. I have very little claim to technical expertise, except I have been teaching a course on Bitcoin, cryptocurrencies, and blockchain for the past 7 years. I was saying earlier at breakfast that when I started teaching the course, Bitcoin was at like $20, but I never invested. But luckily, I also didn't invest when it was $18,000. So anyway, I never have. So we have a terrific panel here. The topic is the artificial intelligence in the courts. So I'm going to introduce the panelists very briefly, starting to my left and moving down the table. Judge Michael Bailson is former U.S. Attorney for the Eastern District of Pennsylvania, and has been a district court judge in the Eastern District of Pennsylvania since his appointment in 2002 by President George W. Bush. Next to Judge Bailson is Director James Duff, who is the director of the Administrative Office of U.S. Courts, which oversees court administration for all of the federal courts. He was appointed by Chief Justice Roberts in 2015. Next to Director Duff, Judge Catherine Forrest. She's a former district court judge here in the Southern District of New York, and she was appointed by President Obama in 2011. She is now a partner at Cravath, Swain & Moore. Next to Judge Forrest, Tim Lau. He is a research associate at the Federal Judicial Center. He formerly worked at Simpson Thacher and clerked on the Federal Circuit, and he is the leading expert on AI in the courts. Finally, Professor John McGinnis. He is the George C. Dix Professor in Constitutional Law at Northwestern University and one of the country's foremost experts on AI and legal technology. And John, I should say, many other things as well. So with that, we have some discussion we're going to have. So I'm going to address some questions to the panel, but also invite participation by any of you. And there'll be a full opportunity to do that later on in this session. So I have an opening question for Judge Forrest. One thing that people often do when they talk about artificial intelligence is talk without knowing what they're talking about. It's not just the technical aspects, but more deeply, it's the definition. What is artificial intelligence in the courts? And since this is a panel about that, I was wondering if you could give us some help in defining our subject matter or subject matterers.
Well, let me start by saying that I don't think that we could probably all agree on a single definition. So what I'm going to do is posit two definitions that really go towards an overall concept of using technology to mimic a spectrum of decision making. And there are what I would consider to be two versions of AI. What is most frequently being discussed as AI today is machines with learning. That is, that machines that have been pre-programmed, machines, I'm thinking of a Turing machine, I'm thinking of a computer. I'm not necessarily at all thinking of a distributed environment, but machines that had been pre-programmed algorithmically. They have had a number of inputs placed within them. There is a defined algorithm, and that machine with learning is then causing results to be disseminated outward. And that is then mimicking certain kinds of human decision-making and human behavior, but it's only with what's been pre-programmed. That's really what we think of in terms of the Loomis case and a number of the algorithms that are being talked about in terms of what pretrial is using right now and what post-trial supervision is actually utilizing. That really is machines that are already with learning. That's to be distinguished, I think, from what a lot of folks out there today would say is true AI, which is machines that learn. machines that actually may start with some sort of initial algorithm, but that actually go beyond where they have been initially programmed and go beyond the initial parameters that had been imposed by the human. For that AI, which is not it's not really been deployed at this point in a lot of places, some would argue, but certainly I don't think we're seeing it in the Compass software or any of the places where it's being utilized with the algorithms today. That is, I think, the more difficult area for us in terms of predicting what's going to be happening. So I would put, to summarize, AI into two categories. That is the machines with learning versus machines that learn. And machines here, again, I'm defining as a Turing machine. In the machines that learn, I think we should include a distributed environment. Machines that are with learning already, we don't have to do that. We can do it as a single machine.
Now, Judge, you mentioned Turing machine. Can you tell us, those of us who are not very familiar with this area, what is a Turing machine?
A computer.
A computer is a Turing machine?
A computer.
Okay, I thought it had something to do with my travel agency. Okay.
TUR.
I think that's very helpful for us. We have, judges put two definitions on the table. One thing that wasn't in your definition, Judge, is just brute things like databases and so on and so forth. I didn't hear that as part of it, but that would have probably been part of the definition 10 years ago.
Well, I would think that when we're talking about machines with learning, what we're talking about is the algorithm applied to the database. And so you're assuming that there's a database underlying actually the algorithm and that the algorithm is drawing upon. So the database itself is actually without learning at all.
Right.
The database is static. That is the data. You may be grabbing it from a variety of places, but it's static. And so it's the algorithm on top of that that really is generating the output.
Great. For Director Duff, you've been involved in this process for a long time, and you've provided important services to the federal courts. Can you give us a brief background of the current state of AI in the judiciary?
Sure. Thank you, Jeff. And just to follow up on Judge Forrest's definitions, would focus probably more on machines with learning that we're utilizing now, both in the context of case management, allocation of resources, and to some extent in the decision-making process as well, as to machines that can learn and apply it. We've been probably a little slower to embrace that, and I would attribute that to a number of factors, all of which I think are understandable and good when it comes to the judicial branch. I think historically we've been not necessarily at the forefront of technological developments. We've been cautious about utilizing them because of both security concerns of the decision-making process and in protecting that. And I think it's also baked into the DNA of many judges. Some judges are certainly more open and embracing new technologies, others less so. Judges are very fond of precedent and stare decisis and in the decision-making process. And that kind of spills over, I think, also into the realm of court and case management. I'll mention a couple of pilot programs that we're involved in right now, active research on learning from data and identifying patterns to streamline our court operations. We use it to great advantage in allocating limited resources. For example, in probation and pretrial officers, analyses of recidivism, people on parole, who's most likely to be a repeat offender based on data that we have collected. It enables us to put parole officers and probation officers on those working with those who are most likely to be repeat offenders, and enables us to save resources in that regard. We had a pilot program also of 150,000 cases and 26 million notes that have been recorded by probation officers to better understand the prevalence of mental illness among defendants for purposes of sentencing and supervision afterwards. That's a very, I think it's a kinder way of looking at the probation and supervision. And we've also used it in multi-district litigation. I know Judge Baleson's been involved in some, but there was a big case in West Virginia recently, Southern District of West Virginia, where we parsed 80,000 filings in 5 separate lawsuits and a large multi-district pelvic mesh case to obtain very important demographics for purposes of the analysis of those cases. It would have cost a fortune to do that manually. So it's being utilized, but we are cautious to dive in first. We do like to learn about it.
It strikes me that one possible reason why the judiciary has been a little slower is that, unlike a corporation, where you can tell your people to learn AI and force them to get familiar with it, it's very hard to tell a judge to do anything. I know, because I've tried and almost always have failed. So how do you encourage judges who don't really have to do what you say to be with the program of learning this program?
Well, Tim.
By the way, Tim will talk about learning.
Yeah, I think Tim can speak to this very well. Our Federal Judicial Center is very involved in that. We have our Judicial Conference of the United States, which is in essence the corporate body of judges who make policy for the courts. It's the 13 chief judges of the circuits and 13 district court judges who sit. So it's a body of 26 judges, and the Chief Justice presides over that, and I'm the secretary of the Judicial Conference. And we set policies for the branch through a committee structure. We have an IT committee, and it's a much like Congress. It's a slow process, and it requires compromise. We're better at this, by the way. It requires compromise and pulling together differing viewpoints of judges and utilizing and encouraging best practices. So if a particular circuit, and I know one of our panelists may speak to a development in the Northern District of California momentarily, but if one of our circuits or district courts has discovered new uses of technology and our AI, we share that. And while we can't mandate it necessarily, some things we can, other things we don't and shouldn't, but we encourage all of our courts to adjust and adopt to the new technologies, particularly where it's cost savings to the American taxpayer.
Well, that's a nice segue into my next question for Judge Baleson. So as a sitting judge who has a wide variety of cases, including complex cases, can you tell us a little bit of how AI is used in your courtroom, or how you think it might be used?
Well, thank you. Well, preliminarily, just by way of background, well, the answer to the question is, as it's used right now in my courtroom, I'd say very little, and very little by myself as a judge, but it is used to some extent by some lawyers in some cases. But by way of background, the first thing to mention is that I know that those of you who are lawyers, you're involved in doing case reading and case research using Lexis and Westlaw. That was revolutionary to a number of judges who were used to subscribing, and every judge was entitled to his or her own subscription of numerous law books, decision books, the Federal Supplement, the Federal Reporter, and so forth. And of course, that has gone into the past. And in our courthouse, for example, what used to be a huge library, double the size of this room, is now a little corner of an alcove, and because there's no need to continue to subscribe to those books. Now, that's not exactly artificial intelligence. But the next stage was the sentencing guidelines. And the sentencing guidelines were developed very carefully over a period of time using statistical data of actual sentences that have been handed down in similar cases. And I think that is a form of AI. The sentencing guidelines have come under attack from many different vantage points. They were originally mandatory; they're now advisory. Many people forget that the prime backers of the sentencing guidelines, who were responsible for the legislation and the authorization of it, were Senator Edward Kennedy and Justice Stephen Breyer before he was on the Supreme Court. And it's remarkable how times can change in terms of giving credit or blame to those two gentlemen who were very much on the liberal side of the criminal justice spectrum, and their prime motivation was the disparity that was taking place in sentencings across the country. And the sentencing guidelines were in large part designed to have some measure of uniformity. Now, since the sentencing guidelines became advisory, every judge is free to use them and to the extent they want. In my circuit, the Third Circuit, all I have to do is start with the guidelines, and I have to decide on the record what the guideline range, sentencing range would be. But after that, unless there's a mandatory minimum, it's up to me. Now, then we had electronic discovery, which most of us call ESI. And that was slow coming to the judiciary as well. And you may not consider that to be artificial intelligence, but there are aspects of it that are concerned. The latest development in that, maybe not the latest, but is what is called technology-assisted review, which judges don't use, but I know that lawyers use it in their cases, and there are a number of judges who have approved it, where a machine, a programmed computer, helps to determine what documents are relevant in a civil case for production. Those are some current examples.
Okay, that's great. Let me turn to Judge Forrest. So you have been a judge, and now you're practicing law, so you've seen from at least those two perspectives, and probably more, and you have a tech background. Can you give us some texture about how you see the judicial function intersecting with AI?
I think that there are 3 points in the process where it's possible that the judicial function will intersect with AI, and I want to talk about sort of the courtroom and the court process writ large. You've got what's happening with the judges and what's happening with the criminal aspects, and we've already got what I'm calling the sort of AI light, sort of really technology utilization. It's the machines that are already pre-programmed being used with the predictive recidivism algorithms already. So you've got the whole criminal aspect that is being then used by pretrial. Now with the Loomis case, you see it being used with sentencing. That raises a whole host of some very complicated, potentially quite difficult issues. But then you've also got litigants and you've got clients. And with litigants, I think that what we're going to see in terms of the judicial process overall is not only the utilization of AI and more sophisticated true AI in terms of the discovery process with predictive coding and the discovery and all of that, but we're also going to see more and more of it taking over functions such as coming up with the dollar amounts for a mediation, utilizing AI to assist with ADR. And so that is another place that we'll see it. We're starting to see that already. In fact, if you think about it, a lot of expert witnesses today who are involved in econometrics are actually utilizing very sophisticated programs to assist them with coming up with what dollar amounts might be. But that's going to be increasingly utilized in a more sophisticated manner, I think, as AI moves further along. The last piece of it is with the clients, where AI is going to allow, I think, for a great deal of cost efficiency and savings in the court system potentially, and also a certain kind of certainty of result. Now, I say all of this but I want to make it clear that I actually have some real skepticism and some difficulty myself with some of the theoretical issues and the philosophical issues that underlie the utilization of AI during certain parts of this process. I personally have a real concern about the utilization of artificial intelligence as it's currently being defined as machines that have been pre-programmed to take the place of decision making, because there's a little bit of a black box phenomena and a lack of understanding of the philosophical backdrop to the creation of the inputs. And therefore, there's implicit bias potentially that is underlying some of the algorithms. And we think of algorithms as mathematical and therefore as they're either right or wrong. In fact, they're full of people's choices as to inputs and full of potential bias. So that's how I see it.
Would you say that the practice of law, say in the sophisticated urban big firm environment, it will be competitively necessary to have lawyers who are sophisticated about AI in order to keep up with developments?
I think there's two answers to that. One is the utilization of various kinds of, let's call it discovery and predictive coding, predictive discovery techniques. That's one. The second is actually practice. And for those of you who are out there who are actually in private practice, one of the emerging areas is actually AI and all of the legal issues that clients will be needing to call upon. And it's a very exciting area. So I think that the law firms are going to have to both use it and be prepared to practice it.
Right. I can see it as a selling point with a client when a lawyer is bidding for a case or being reviewed to say, we have a sophisticated AI system at our firm. We can offer this to you, and it might be a way to convince clients to retain you rather than someone else. Not you personally, but yes. We've talked a little bit about judicial education and how judges can learn or be persuaded that it's in their interest to learn. And the person who's most involved in this topic, probably in the United States, is Tim. The Federal Judicial Center is very active in working with judges to develop a greater degree of sophistication and utilization of AI. Can you talk a little bit about the efforts that you and your agency have undertaken?
Okay, so just as a bit of background, the FJC, the Federal Judicial Center, is the research and education agency of the federal courts. It works closely with the administrative office, and you could think of us as kind of like the internal think tank of the federal courts itself. So part of the education is that we learn from the judges what they need and communicate it to you. That's I suppose why I'm here. And also to learn what the parties and what industry needs, and to, in some sense, educate the judges as well. So it's a two-way street. If there are conferences, I don't want to travel too much, but let me know about it. But in terms of education, I would, for example, prepare these pocket guides. You could go on the FJC website to download them. You would have seen them if you were a judicial clerk or a former judge, but these publications are not very well known, but they exist, and so we are preparing those as well. In terms of educational programs, we are already in the last district judge workshop. So every 2 years, the FJC holds a district judge workshop to get the district judges who want to go to a week-long workshop to talk about issues together. And in the last conference in Santa Fe, we had an AI discussion, and we may have more in the future. And even then, we are also organizing other programs. Like we will have a program at Duke University organized by David Levy in May on cybersecurity, cryptocurrency, blockchain, and AI. So those types of programs exist. We may also have webinars. These things happen. The public don't necessarily know about these things, but they are happening. And we will have internal educational programs and materials for judges.
So let me ask a question maybe for you and Director Duff also. Assume that a judge has a case before her or him, and the judge has to consider sophisticated issues involving AI. And the judge, of course, went to liberal arts college, wrote a senior thesis on Shakespeare, and went to law school, knows how to type on a computer, but that's about it. And none of the judge's law clerks knows anything else. Is there an avenue by which the judge, consistently with the judicial function, could reach out to someone and get advice about the technical aspects of the case, other than through the attorneys who are going to provide, shall we say, party biased views?
Well, in terms of making phone calls to people to ask directly, they could have technical experts, and that's a different, the technical advisors, I think they could appoint one, and so those are provided in the rules of civil procedure. In terms of written materials, we would have these pocket guides. For example, there's a pocket guide on technology assisted review that we have already published, and so the judge just needs to go onto the internal website. So there is an internal website for judges, and they would go find these materials. So we have materials ranging from the reference manual on scientific evidence, which is a huge book. Again, not many people know that this exists, but it does. It's one of the most cited publications of the FJC. And there are also these pocket guides that supplement the reference manual on more individual, concrete technological matter.
Okay.
I might add to that there's there are probably two levels of that. One is just getting a fundamental understanding of AI, which I think Tim has spoken to. But judges can consult in the context of their decision making outside experts, and but it does raise ethical issues in that when a judge does that, she has to inform the parties and give the parties an opportunity to object. There has to be a substantive disclosure as to the consultation of for expert advice outside the realm of the case in front of the judge. So there are ethical issues that do arise ultimately, but Tim's absolutely right. We have a great deal of material and resource information for judges who need to get up to speed on the topic.
Well, let's say a judge did want to go outside to an expert as permitted under the federal rules, but the judge simply has no idea who to ask. Is there a resource, it's kind of a referral network that's provided to judges where they might?
Yes, there's data available of experts in many fields, and there's an organization of scientists who they publish their own compendium of different disciplines and people who are experts in it. And I know that some judges have consulted that. And as the Director Duff said, there's a federal rule of evidence on this, which allows the judge to appoint an independent expert, but it's after disclosure to the parties and giving them a chance to comment or object, and also arrange for payment.
Yes, rather important for experts.
Yes.
Judge Forrest mentioned some concerns about AI in terms of the jurisprudence of it, and I wanted to direct this question to Professor McGinnis. So everybody agrees, I think, that AI is an important innovation. It's already affecting how the law is being administered in various ways. But are there, in your view, broader implications for jurisprudence? Do you have any concerns about where this is heading?
Well, I'm interested in maybe broadening the discussion. We've talked a lot about how AI might be used in the current jurisprudence. One other question, though, is to suggest how might AI change jurisprudence, change the relationship between rules and standards. And I'd introduce this by an interesting statute that was in Montana, which said drive at a reasonable speed, which is very different from most speed limits. We actually have a rule. And the Supreme Court there struck down, invalidated that statute, saying, well, people didn't have notice about it. We really couldn't figure that out. Well, think of our world, maybe not today, but certainly I think in the relatively near future. I don't think it's very hard to imagine an app which would look at all the different factors, the road conditions, the road standard, the weather, the time, and predict what a judge would say what a reasonable speed would be. So that would be a lot more notice. And so you might start to think in that world, you should be more open to creating a jurisprudence of standards rather than bright line rules. This debate between standards and rules is a very old one in law. One way I might illustrate it, in the 19th century, there was a debate about the move to codes, and the arguments for codes were just that they were more transparent to people, they were clearer, they informed people, they took away discretion from judges. Those who opposed it said, well, the common law principles capture complex realities. They also make it easier to update as people learn. So the presence of AI is not only sort of exogenous, it could actually change the law endogenously. Now here I'm talking, note, about apps that would help predict what judges do. Of course, Holmes famously says, what judges do, in fact, really nothing else is what I actually understand the law to be. I think that's itself a controversial position. But this looks at law as being embedded in our technological structure, and so there may be different kinds of rules that we'll use to get advantages of the possibilities, not actually in the judiciary itself, but used by citizens and by lawyers. Insofar as we can better predict the law, we may be able to actually move to standards which will be more efficient. To go back, of course, to the Montana example, the way, of course, it's more efficient to have a reasonable speed is, of course, it's not always sensible to drive at any particular speed, and the standard does capture that complex reality. Moreover, it's easier in some sense to update as changes happen to roads and actually to cars. So I think there's a larger question of how we think about the nature of jurisprudence once we embed it in a world that's full of AI. And here I would talk about AI in Judge Forrest's sense, AI that actually can learn, because these apps will be learning as decisions come down from the courts.
So there's a lot of ideas in what you said, John. So one is that I'm wondering about the function of law of providing clear notice to people about what they have to do and not do. And if you have a system where the determination is based on a computer algorithm, how is the person going to have notice about what they're going to do? It's one thing to say you drive 55 miles an hour. If you're a lot over that, you get busted. But if you just say drive reasonably, how does a person know whether they're complying with the law or not? Yeah.
Well, the idea would be that people would have an app in their cars, right? That's ultimately what we'd be doing. We'd be giving them a sense of what judges were going to do. So that in some sense, you might say they'll have as good an idea as they will have today. You could have that as a commercial matter. You also could think of a structure in which the state would give everyone the opportunity to have an app that would capture all these factors as someone was driving. And so the idea would be to give them the kind of notice that you do have from an abstract and singular speed limit, but one that would change and help people at any particular time know what they're doing. So let me just make this a little more abstract, right? The difficulty also that people have is to know what the law is at any point about a whole variety of things, insofar as we think of AI as being able to deliver information about their particular situation and what would be the relevant law in this situation at any time. Notice should be able to be increased overall.
Okay, I know other panelists want to speak to this. Tim, I saw you had you wanted to say something.
Well, so I think we should, in some sense, I think the standard organizations, setting organizations like IEEE would fill in a lot of the gap. And so let me just just put it more concretely. If we want to predict what the future will look like in terms of driving, I know this is going to offend the hearts of every American, but stop signs and traffic lights are not efficient compared to roundabouts. So in the future, we would have, and in the future, we would probably have, and I'm talking about by the time on my deathbed, what driving will look like. There'll probably be no traffic lights at all, and that everything would be roundabout. The cars would all talk to each other and just drive around roundabouts, and so they would appear and disappear at any time depending on the need, whether there's a car driving in that area. And under those circumstances, there may even be no traffic signs because all cars are self-driving at that point, and they are all talking to each other. And those aspects, right? It may just be the standard or setting organizations, IEEE or other organizations like that says, a car should be driving at this speed, it needs to meet these criteria in order to drive. And to the extent that these may become part of law, interact, and we're talking about how the Department of Transportation will interact with these things, but it will be more, as I see it, if we're going to talk about these type of things, it'll be set by organizations beyond the judiciary, I think, in terms of like what is a reasonable speed. It wouldn't just be what the DOT and NIST and IEEE and all those industrial groups coming up to say, oh, here's how a car should drive.
Judge?
Okay, three comments about this, which I think are predictive of what may be happening. It so happens, if any of you have been to Martha's Vineyard, where I spent some time in the summer, there was a big intersection there which for decades had a flashing stop sign on one side or the other. And the debate would go on about which of these two busy roads would have the stop sign. And there were traffic jams for a half hour or more in the rush hour. 2 years ago, finally, a roundabout was put in. There are no longer any traffic jams whatsoever at this intersection, to prove your point. Secondly, in terms of driving reasonably, and many people predict AI is going to lead to driverless cars. Well, one aspect of that, nobody wants to be is supposed to be looking at their iPhone with their apps while they're driving. But in theory, you could have, with a self-driving car, you could have a maximum speed limit set by the vehicle, that the driver would not be there, obviously. The vehicle would slow down to a pre-programmed speed when a certain traffic item happened. Maybe it was another intersection, they'd have to come to a stop, they'd have a roundabout, have to go around, etc. Getting back into the judicial function, I think it's important in talking about AI, it's to draw a big red line between criminal proceedings and civil proceedings. And yesterday in the Loomis case, those of you who were here, I don't think a judge would tolerate a black box algorithm in making a decision as to what sentence to impose on the person. I think, the defense would clearly be entitled to some discovery. It could be a protective order because it could be proprietary information that went into the calculation. But I think the defendant would have a right to know what data was being assembled to possibly give him or her a higher sentence. However, once an individual is sentenced and they're on parole or probation, then I think it's entirely appropriate for the probation officer to use AI in terms of algorithms and experience to help this individual not commit another crime. Society has a big interest that people who have served a sentence and they're back on probation or parole or whatever the state or court may require, that they get the maximum amount of help and they're still under restrictions. So there's a whole continuum in our society that we have to address on these issues.
Judge Forrest?
Yeah, I want to go back to a point that I made earlier, which is one concern, and I think it has to be addressed at sort of each and every step, is that these algorithms they are not just unweighted inputs, right? They're not just based upon unweighted inputs. Every single choice in terms of an algorithm is going to be weighted. And so what goes into the weighting, even if we're talking about the road conditions, talking about sort of that most basic issue, what should the speed limit be? It's going to weight weather. It's going to weight road conditions. It's going to weight a particular urban environment versus a rural environment, and there are going to be choices that are going to be made. When we extrapolate from that, okay, and we say, okay, well, that's not just a matter of taking data on how fast the car is going. That's not how it's going to work. It's going to work based upon the reasonableness, based upon a variety of other factors that are underneath it, and query whether or not these industrial organizations are going to be exposing to us exactly how they have weighted all of this. There'll be competition between various organizations as to which is the best weighting and the most predictive weighting, and query whether or not judges are going to be using algorithms or being driven by algorithms. And I think there's a real difference. So then when we go from that to other kinds of proceedings, let's move away from drivers and speed limits altogether, but to the much more difficult issues. It's not just criminal, but there are also civil enforcement penalties where you've got similar issues that are going to come up in terms of weighting. So of course the criminal, I think we understand how that's going to be very problematic. But if you think of SEC actions and you think of civil enforcement penalties and you think of the way in which even there it may be civil, but there is going to be a variety of ways in which if you were ever to try to use an algorithm, the weighting of the inputs is going to be extraordinarily important and difficult. So there are some real philosophical issues, I think, that are embedded in the utilization of this kind of technology. Let me just say one more point, which is that judges actually have to put their decisions out in writing and have rationale.
Right.
And that's incredibly important to our common law system. We are not a civil code system. And when you've got an algorithm that essentially is driving what constitutes reasonableness, you're moving away from the narrative articulation of that decision making, and you're moving more towards what I would consider to be a code-based system.
So a couple of thoughts about that. Would you make a distinction between the use of artificial intelligence to develop the standards and the use of artificial intelligence to apply the standards to a particular person or case? Because, for example, as I understand it, the sentencing guidelines are actually based on a great deal of information that has been econometrically and statistically processed in very sophisticated ways to come up with the guidelines. Is that different, Judge, in your view, than the application of these guidelines or any set of rules to a particular person using predictive technologies?
Yes.
And why?
I think that the ability ultimately it comes down to whether or not we've got AI, which is learning and going beyond the ultimate, the underlying algorithm, or AI that's staying within the parameters of the algorithm. As you know, I don't really think of AI as staying within the parameters of the algorithm. I think we can use that terminology here, but it's really just high tech and not AI. Once you've got AI, true AI, it's going to go beyond the parameters of the underlying algorithm. And so it's going to, going back to your point, ultimately, you give me that one last piece of your question.
Well, I was just asking if you see a difference between using AI to develop the standards as opposed to using AI to apply the standards in an individual case, for example, in sentencing.
And I think that ultimate AI will do both. If you were to sort of say what is AI and what is sort of AGI, artificial general intelligence, it's going to ultimately do both. But with high tech, we can actually control it. And I think it ought to be that humans, for a very long time, control the parameters of it and understand exactly what the inputs are and have a lot of transparency in that.
Mm-hmm. This strikes me as a problem not only for judging, but for any decision making. So, for example, if you have a board of directors of a company, they get given dashboards by the staff that have red, green, and yellow next to different criteria. And what the board looks at is it green, is it red, or is it yellow? And if it's green, they don't pay much attention to it. If it's red, they get worried. If it's yellow, maybe they ask questions. But those dashboards are based on underlying analytics that are not explored by the board of directors because they don't understand them. And the parameters are set by people who are not being reviewed by the board. So I think it's kind of the same thing as what you were saying with judges, that how you set your weighting is not transparent. and yet it generates an outcome that drives results. So I think it's a broader question, actually. Let me go to John. So Judge Forrest John has given a rather strong critique of AI. You presented an optimistic view of AI in the future as leading us all towards a better world where we can have standards and not rules, things go quicker. But Judge Forrest has said, well, wait a minute, we have to worry about the inputs, we have to worry about self-fulfilling prophecies where the AI creates the result. We have to worry about the transparency of the judicial narrative, about describing the reason for a result. So those seem to be pretty powerful critiques. Do you have any response to that?
Well, I think there's been a slight moving from the use of AI. My discussion was of the use of the AI outside the courts and how it might change the standards that judges and other decision makers, including legislatures, would make about the rules within the court. So that's quite different, I think, from the issue of how we should use AI within the court. So, by example, of course, it was really just an example from driving for heuristic purposes, is the idea that there'll be updating through apps on predicting what the law will be. The judges will be setting the law. In fact, I wasn't even necessarily thinking judges would be using AI in any respect in deciding what reasonable speed would be. And I think that's going to be our world, right? It's not the world in which AI is going to simply be part of the judiciary. It's going to be out there in the world. And so one, I think, very important question is not simply how AI is going to be used by judges as substitute algorithm for their decision making. I'll say a word about that in a moment. But how the nature of jurisprudence will shift given the presence of AI in the world. So I just think there's a slightly different question, but I still think it's relevant to the nature of the judicial function to think about the judiciary as embedded in an AI, a much richer AI world. With respect to algorithms, I mean, I certainly take the points that one needs to be very worried about the discretion that they might have. I do think one always has to not, though, compare it to absolute confidence that we're not getting a lot of discretion smuggled in by judges. It's, of course, a legal realist point that we're not always confident that what judges are saying are actually what they're doing. One advantage, at least if you have a structure of verification of the algorithm, is you may actually sometimes have you might have in certain circumstances at least a different kind of confidence than you do with respect to judges. So I haven't really thought about that. But the question of how you would actually, you might use algorithms to test also the honesty and at least the sincerity of what judges are saying might be useful as well. But I think the more important point that I'm making is that we shouldn't think about AI just in the nature of as an input to a judicial function, but the judiciary as a function of a world where AI it becomes much more present.
Yes, Director.
And just to follow up on that, I think the key to what John is saying too is that the public and parties' rights to know what goes into the decision-making process ultimately, and what's the data that is being relied upon. It reminds me, there was a well-known umpire in the 40s and 50s. I'm blanking on his name right now, but he was notorious for being slow and making the call if it's a ball or a strike. And there was a pitch, and the batter got tired of waiting, and he looked around at the umpire and said, well, what was it, a ball or a strike? And the umpire said, son, they ain't nothing until I call them.
Very quantum mechanical.
What the batter wanted to know, basically, well, what is your strike zone? And I think the decision-making process is very much like that, and the public's right to know, and parties especially, the need to and right to know what goes into those decision-makings. And ultimately, it is the judge's call. But the data that's being relied upon is going to change, and there'll be many more resources that courts and judges utilize. But we have to be transparent as to what those are and what that data is.
Tim?
Hey, so I want to respond to Professor McGinnis's point about how would things be, say, reasonable, or like how would judges try to set standards and things. And we could look into the example, and by the way, I'm not making any normative points, I'm just commenting on what's happening. If we look at how things are being done in the forensics science area, which in many ways has parallels to the AI area, we see the importance of accreditation of forensics experts, that that they are performing. For example, a judge isn't going to go, generally at this time, they could, but I don't think they would. How would you look at a bullet mock and say this is a match? I don't think judges are going to go set that type of standards, or they could, but I don't think they would say, oh, this is how a bullet looks like another bullet. It's an entire discipline of its own, and these are set by accreditation agencies. The NIST looks into these types of things, and they have their own set of structures saying, oh, what is, how would you reasonably call this bullet a match to this gun? And these tool marks, and you would have the same type of matches for DNA matches. Like when could a DNA expert call a match? Well, the DNA expert will be accredited. There will be standards developed in those areas about how these things are done. Judges so far, I don't think, would go and say, I need XYZ before you could say that this DNA match is a DNA match. Like, I don't think many judges have that expertise to do so. And I would say the same probably will happen in AI as well. The standard settings organizations, yes, I understand that there will be a problem with conflicting standards, and that will be issues that will have to be resolved. But I think that this type of extension, if you will, of what is acceptable behavior may not necessarily come from judges, but from industry organizations or people who actually really know how this is done.
So this topic we've been discussing has an inherent element of futurism in it. We're not only talking about the present, but we have to predict the future. So I'm going to project a future. And I'm reminded about self-driving automobiles. So we may have we already do have self-driving automobiles where someone sits in the car, but the car makes all the decisions. And eventually maybe a car which nobody has to sit in, prepared to drive it, the car will do it all. Let's imagine we have self-driving judges where the judge sits at the bench, but there are a set of cases that are relatively routine. Say the judge has to deal with speeding tickets or Social Security disability or other types of cases that come in and have a fairly routine quality to them. And instead of the judge making a decision, the judge simply sits there, the information is input, and out comes the decision, which the judge then basically approves. So the judge is sitting there like someone in a self-driving car, but the AI system is making the decision. Now, would that be a good world to live in, where the judges just sit there and a sophisticated, vetted, validated AI program is kicking out the result? Is that a world we'd like to live in? Yes, go ahead.
Well, I think it's a world that, as it evolves, will have different feelings about it at different points in time. I think that there's a point when you could imagine very far down the road where it could become very sophisticated. But I think in the meantime, there are certain aspects that would be lost that AI simply at this point in time is not sophisticated enough to replicate and won't be. People say that we won't hit a point of AGI until, 2040 or something like that, if you look at what some of the MIT predictions. But at the end of the day, AI right now can't judge credibility, and it can't weigh the evidence in the same way. So even things like speeding tickets, there may be issues as to not exactly how fast, but the why, and the why can affect things like the quantum of the amount of penalty involved. For things like Social Security, of course, credibility determinations are extraordinarily important. And so what you've got is you'd have to have a situation in which AI was actually able to essentially act and mimic a polygraph and or be able to analyze voice and other kinds of data to determine credibility. That is something that is very far in the future. And it's not that I wouldn't want to live in that world if it developed in a way that was incredibly sophisticated. It's that I'm worried about getting between here and there.
But Judge, let me push you on that just a little tiny bit. It seems to me the issue is not whether AI can judge credibility or other features. It's whether AI can do it as well as or better than a human being. Because human beings also make lots of mistakes about credibility, and they make lots of mistakes about evidence and so on. So if AI, so that's a less demanding criteria. We don't demand that it be perfect. I don't think you were applying that. But we just ask that once AI gets to the point where it's as good or better than a human being, that at that point we give it to the AI program. It's just like chess programs have now got to the point where they're actually better than human beings. So go ahead,
Let me
Judge.
just say, I think that would be terribly dangerous and really very bad from a lot of ways. There are human elements. After yesterday, and I said this before we started this morning, I was convinced that I had one of the least threatened jobs in the United States because yesterday we saw that lawyers are being challenged by AI, so are doctors and architects, but I thought judges were safe. Now, Professor Miller is challenging that, but speeding tickets, just to take an example, in most speeding cases, there is usually some kind of quasi-scientific evidence or real scientific evidence, such as radar, that the person was speeding. But I've been in court sometimes, not as a judge, but when I was a lawyer, who the driver would say, Judge, I did speed, but I've got a wife and 5 children, and I had to get to work that day, and I couldn't afford to be late. I would have been fired, and if you find me guilty, I'm going to lose my license, and I'm going to lose my job. That's a human factor that no AI can ever account for. And the judge, therefore, might say to that young man, all right, I'm going to find you not guilty. And in Social Security, as Judge Forrest said, there are numerous human factors that go into the decision-making process.
Let me just jump in here. Well, that may well be true about a class of cases, but it strikes me the way, again, this is likely to come not through the judiciary, which, with all respect, is probably, for good reasons, more slow-moving than other aspects. It's likely to come through arbitration, because there are contracts where they're contracts between merchants. They're really not concerned about human sympathy, but predictability. And so the question will be simply, will this arbitration, this AI arbitrator, will this give more predictable standards and therefore result in a more optimal contract? That is, I think, where we're likely first to see these matters, and maybe very simple matters where the matters are dictated by what are called oracles. So you just see where certain inputs are, information is inputted into some mechanism. So I think there is a future for that. It's likely not, and appropriately so, not likely to come up directly through judges, but through arbitrators, and then judges will take account of this and then maybe start to implement some of it within their own sphere.
I think that would be a positive development in the field of arbitration, because the problem we have with it now is there is it's predictability. Arbitration these days has replaced litigation in the federal courts to a great degree, and there's been a detriment to that, in that the public and people don't have a body of law to look to in decisions that are published out of federal courts. Arbitration is geared to individualized justice, and it is applied to just those two parties, and decisions aren't necessarily published. and others can't rely on those for precedential purposes. So if arbitration moves in a direction that has and utilizes more AI, and it's disclosed as to what's going into the decision making, that gives predictability, and that's good for the public, good for the parties. And I think you're right, John. I think it's more likely to be developed in that realm than from the federal courts generally. But the courts will adapt to it. I would add one other thing to what Judge Forrest has said, and Judge Bailson too. The last time I was in New York, I was fortunate enough to get a ticket to Springsteen on Broadway, and I'm reminded of his great tune, Human Touch. And I think people need the human touch, and I don't think the public generally is going to give that up in the field of decision making. And it's very important, as Judge Bailson described, to be able to, and I think this is also another reason why the mandatory minimums and sentencing guidelines are not well liked by many judges, because it takes the human touch out of play and out of consideration in matters. So I hope we don't head entirely to.
Well, I was not necessarily presenting the idea as a utopia. It could be a dystopia as well. So we have an opportunity for anyone here to ask any questions. So does any of you have any questions you'd like to direct to the panel? Yeah, go ahead.
I'd like to ask Judge Forrest to elaborate a bit on the philosophical aspects that you referenced. Elaborate on.
Yeah, I think that this is most easily seen in the context of the utilization of what we've been calling today AI in the algorithms in the criminal context. And so we've seen in the sentencing guidelines, for instance, that the sentencing guidelines are an amalgamation of every philosophy of criminal punishment that exists. And they're sort of all in there. All the 3553A factors we'll talk about, each of whether or not it's retribution or whether or not it's incapacitation. They're all sort of squished in there. With AI being utilized, for instance, to predict recidivism, what we're essentially doing is we're making a judgment based upon a philosophy of criminal justice. What we're saying is that potentially incapacitation may be the driving force, and that may be prioritized above other aspects. For instance, rehabilitation. And so if you're looking at somebody's risk factors for whether or not they're going to reoffend, and that's going to drive the algorithm, you're looking at whether or not incapacitation perhaps is going to be the leading philosophy that's undergirding that algorithm. Well, what about rehabilitation as something entirely different, where you may have a certain tolerance for a reoffense, but that is balanced by the overall improvement and well-being, not just of that individual, but of the family unit. Because there are aspects of reincarceration that are going to affect more broadly, more than just that one individual. So for each aspect of criminal justice, whether it's retribution, whether it's incapacitation, you can go through all of it. The question is, who is making the judgment about which aspect is driving the inputs? Because that's going to drive the weighting. And I think today, what we've not done with the Compass software programs and the similar programs is we've not asked them what the philosophy is, and we have not asked the judiciary to examine closely whether or not we are in agreement with those philosophies. So, and indeed, the same may be true of the sentencing guidelines, but let's put that to the side. So that's what I'm talking about.
May I just ask Judge Forrest a question? Would you be happier if the code spits out multiple possible outcomes based on the different philosophies? Like, instead of presenting you only one number, it would present multiple numbers. Say, based on a rehabilitation, this should be the treatment, or multiple options.
Yeah, I don't think it's not that I don't think it can be done. right? I think that we're going to enter a world where it's going to be done. I think that the question is one of process. And so we're going to have either whether it's going to be choices as to what philosophy for that particular human being with a particular storyline is going to be the philosophy that's going to be the predominant philosophy for sentencing. There are individuals who come up for sentencing where they've got a list of prior conduct that is, they've got 27 prior offenses, but they're all drug offenses, they were all petty offenses, and they are now 55 years old, and they say to you, Judge, I'm done, I really am done, and you feed that into a machine, and it's going to give you one output, but you give it to a judge and a human being, it's going to give you another. So I think there's a way of capturing that difference over time, but it's a matter of process in terms of having the judges be able to understand exactly what the choices are and either decide to apply those choices or to change the choices, et cetera, et cetera. So does that answer it?
Yes.
Yes, you had a question?
So,
This gentleman.
oh. Professor Miller, you referred to a possible distant future in which routine cases would be decided by AI. But in many jurisdictions, including my home jurisdiction of New Zealand, we're some way down the path of doing that, but with safeguards. And my favorite example is child support decisions, where parents separate. Those used to be made always by family judges. Now we have an initial automated process. There are a number of inputs that go into it. You get an initial automated assessment of the child support to be paid. But if either party is dissatisfied with that, the payer or the recipient, they can ask for a review by a human judge applying a broader set of criteria, taking into account the special, unique circumstances that came up in the driving example. If AI is used in that way, to have an initial run at a decision, but with the opportunity to have recourse to a human judge who will produce reasons and a more broad, more nuanced decision, do the same objections to the use of AI in judicial decision-making still apply?
Any response to that? Interesting.
Is that directed towards me? All of us.
Yes.
I think the place where it's being utilized with child support is one place where the weighting, I think, is actually done a little bit differently. In the examples of child support that I'm aware of, where it's actually sort of inputs on things like income and just expense and budget line items. So it actually, I think, involves fewer of the problematic areas, but not limits them. I do think recourse to a human review at this point in time solves not all the problems, but solves certain problems. But I also would believe in transparency as to how that algorithm came up and what was driving any weightings that may have occurred.
We already
That's
have
my
a procedure in federal courts for magistrate judges, and magistrate judges often make recommended decisions, and it goes to the Article 3 judge, who then decides, do I approve this or not? And the judge can use discretion, but very often the judge approves what the magistrate judge has suggested. So if you had an AI program instead of a magistrate judge with the district court judge with the ability to override if the judge thinks it's unreasonable, then maybe that would address some.
This can come up in just civil discovery where one party says, well, I've used technology-assisted review in producing my documents, and the other side says, well, I'm not going to accept that. I want to have the judge review what my requests were and what I got instead and what I think is still there that has not yet been produced.
Yep. Go ahead, and we have the question.
If I might just mention, I think that this is a very good result, because I think also it puts some discipline even and allows us to evaluate what the subsequent judges do compared to what the baseline is. I mean, I come back to the point that we cannot be confident that human decision makers are not biased, and this gives more information in a statistical sense to hold their feet to the fire. So I think there's another advantage, actually, of that structure.
You had a question.
Yeah, so I'm not a lawyer in any shape or form, so I what I'm asking might be a little naive, but I'm going to put it out there because I think there's been some really creative and bold thinking. But I wonder if AI might be able to push it even further and sort of really, if you're thinking about the future of the legal system enabled by AI, it might actually change some of the very foundational elements on which the legal system that we've always had is based. And one of those is that the law is sort of very binary, that it's innocent or guilty, and it's black and white in some sense. And you for instance, one example is there's a lot of discussion about speeding, right, and driving, and speeding is something. No one is innocent of speeding, right? So everyone's guilty. Everyone's a little bit guilty. And if you look at how speeding laws are usually enforced in the real world, it's a situation where everybody was speeding. One person was sort of unlucky enough to get caught randomly, and that person is being punished. Everybody else that was driving by them at exactly that same speed sort of is just driving by, right? So it's just the completely random black and white situation. The real goal, though, is not to prevent speeding. The real goal is to promote safe driving conditions and to reduce traffic fatalities. With AI, with the data we have, we could imagine a world in which that is done much better, where you have data on how much I am speeding every minute that I'm driving. You have data on how much I'm weaving in and out of traffic, which actually is a bigger deal than how much I'm speeding. You have data, as you were saying, Tim, on traffic conditions and how fast everybody else is driving. So basically, you could have a situation where you give everyone like a monthly surcharge instead of this black and white. Everyone's a little bit guilty, and you sort of really truly mirror the behavior of the person, right? So that's sort of one thing. The other thing is, the judicial system is very much based on it's punitive, right? Rather than, and you talked a little bit about, what one of you did about sort of rehabilitation and prevention. But if that's the ultimate goal, there's a lot to be learned from behavioral economics and psychology on whether this assumption that carrots and sticks really get people to behave the way we think they do is actually not borne out when behavioral economists look at it. There was a lot of discussion yesterday about recidivism in the Loomis case, and it sort of struck me that the assumption was that if you put someone in prison for 2 more years, they're less likely to repeat, and actually it might be the opposite, right? That if you look at the conditions in our prisons, you look at what prison does to people, they're actually more likely to repeat, right? So the opportunity to bring behavioral economics into it, to use AI to personalize that, and to create a system that is truly based on how people behave, and is truly preventative and rehabilitative. And do you see any potential for any of this? What do you think? Again, I'm not a lawyer. Maybe I'm coming out of that field and being really naive about it. But it just strikes me that there's an opportunity to do a lot more.
Although you're not a lawyer, you made a very persuasive argument just now. Do any of our judges want to respond to counsel's presentation?
Let me just say that I think it raises an important issue, which may not have come out from my prior remarks, and I may have portrayed the view that AI is all a negative. I don't think so. I think it's a matter of process, which I'm very concerned about. I do think that AI has the potential to reduce disparities in ways that are very important. I think, though, that there are normative judgments in terms of where the disparity, what is the right point for the reduction of the disparity. And those normative judgments concern me quite a bit. But I think that AI does have the potential, for instance, to reduce disparities in sentencing. We had the same issue with the guidelines back when they were originally created. There's a goal that's admirable. It's the process of getting there that is quite difficult.
Judge Bailson?
I would agree that I think judges welcome information from whatever source, as long as it's reliable. Reliability is the key word, but the decision-making ought to be the human input.
David, are you there with a question?
Yeah, I
Or are you
actually
there
do have a
kind of
question.
controlling
Is this
things?
on?
Oh, ask your
Yeah.
question.
So we've been hearing a lot about possibly the future of courts or how courts relate to AI, but I think a lot of this is predicated on having data. Federal Judicial Center does a very good job of sending out some summary data and making it publicly available, but access to raw data on the courts is very difficult to come by, and it's even worse in the state level. What can we do moving forward? I mean, open paste or something that a lot of people want, but I know that's kind of unrealistic. But what can we do to get access to more raw data, to be able to analyze the actual dockets themselves, to see what's going on in these cases, so we can start to build things?
I think that process is starting, and we're taking it very seriously. We have a new director at the Administrative Office of the Courts on data gathering and supervision, and he's very attuned to the interest in it. Once again, I think we're being cautious as we go forward in putting it all out there, but we've heard the need and interest for it, so we're working on that.
So a fascinating panel, thank you. So one topic that I thought I might hear more about, I'd like to hear the panel's opinion on, is access to justice. So the current justice system, especially I think in civil justice, is very expensive for people to get justice. It takes a lot of time and can, I think, be prohibitively expensive for a lot of people. So I'm wondering the extent to which you think that AI, even if not sort of the perfect human touch, by giving greater access to justice, making justice less expensive for people to get, could be a net positive.
Any thoughts?
I think that automation adds to efficiencies. I think we've seen that in a variety of ways, and I think that there are certainly areas where people could opt in, if you will, and there could be very, very efficient ways of dispensing certain kinds of justice. I think it depends on what we're talking about. If we're talking about an employment situation, that's one thing. If we're talking about a Social Security appeal, that's something else. But I think that the ability to automate and to create efficiencies is real. And I think that people having access to that is very important.
I think there is also a distinction perhaps between federal courts and state and local courts in that regard. And the vast majority of people's access to justice is at the state and local court level. And I think it, just as was described on the New Zealand practices, there's probably more potential there. The percentages are it's like 90% of case law, it comes out of state and local court, only 10% out of federal. So I think that's the state and local courts are likely to be where the biggest action is in that regard.
We have time for one more question. Did you have a question?
Hi there. Oh yeah, you can hear me. So my question is really about what makes you think that this assumption that these machine learning algorithms are actually going to be better than human decision making? And I asked this question because I guess Kathy O'Neill yesterday mentioned this case where Amazon's hiring algorithm just perpetuated, it had biases against women. It perpetuated a lot of these recruitment issues that we have. The data that is being used, that's already out there, is biased. It collects data on what judges, presumably, maybe in the future, would have already done in the past. So we already know, based on research, that the data is biased. It perpetuates what has happened in history. What makes you think that using these tools is necessarily better than humans?
Well, first of all, I don't think anybody actually said that, but that is a very valid question to ask. So
That gets to the point of reliability. If the data isn't reliable, it shouldn't be used. And that was one of the problems in the Loomis case, that the data that was being used for this extra 2 years was supposedly a trade secret that nobody had access to. And I don't think most judges would allow that to be used in that situation.
What data will the appellate courts use, and what algorithms will the appellate courts use to review the lower courts' use of algorithms and data?
we need a meta algorithm.
And let me just add that I think part of the point is that the data itself is reflective of a current environment which may embed biases within it. And so the data is maybe what the data is, but that data may be reflective of biases. And so if you're going to utilize data reflective of biases to create then and to be utilized to create answers, you're going to be reflecting those same biases. I think it's a big problem.
Yeah.
And I think that's I think it's a real concern.
So what we've learned from this panel is that AI in the courts is great because it's going to reduce cost and access to justice. AI in the courts is very questionable because it's going to perpetuate bias. AI in the courts is wonderful because it will lead to a utopian future where we get better decisions and more efficiency. AI in the courts is dystopian because it replaces the necessary aspect of human judgment with a machine. So I think we've concluded all things, and that's the mark of a good panel. So please join me.
Thank you, Jeffrey.